Hello, everyone, and welcome to the webinar. My name's Kate Burt, CEO of Hive, and I'm delighted to bring this 𝗲𝗲𝗂𝘁 webinar to you today. Before we get into it, I just want to do a little bit of housekeeping. So the session today is recorded and you will be sent a copy of the recording after the session. There is an interactive feature, so there's a Q&A button and a chat if you can access it. If you can't access the chat function, then please do use the Q&A and we'll keep an eye on that as we go through. There will be a little bit of a Q&A session at the end as well, but depending on what comes through, we may pick that up as we go on. But without further ado, welcome to this session on the aptly named law. What are we called? What are we called? It's really catchy. Heather, what are we called? Law firms. Law firms.
Data AI,
oh my, yeah, exactly. So in the sort of behind the scenes as we were brainstorming that, you had a little bit of an epiphany, didn't you, Heather? It's like, it's got to be like lions, tigers and bears, oh my sort of feel. So that's where it came from. But it does feel a little bit like that in terms of there's so many shiny things flying around in terms of AI. We're being bombarded with all this, potential of AI. But really, how do you control the risks that are inherent? You may have a policy in your firm where you say, we don't use AI. It's happening in your business, whether you know it or not. It's so readily accessible in all sorts of different ways that it's happening, but how do you control that? And really, that's the purpose of this webinar, is to look at some of the controls as to how we can safely use AI, not to stifle innovation, but how we can really harness it in a safe way. So I'm delighted to be joined by both Heather and Peter today, both renowned experts in their field in relation to data law and regulation. So I think without further ado, firstly, I think we're starting with you, Heather, and I will try to share the slides.
Excellent.
Hopeful that this is going to work. There, are we good?
Yes, we're good.
Lovely. Over to you.
Great. Hi, thanks everyone who's joined or joining. We're doing a lot around AI right now because it's the fabulous 𝗲𝗵𝗂𝘂𝘁, and one of the things I do in particular is sort of talk about technology in law and make it understandable, because we are legal professionals. We're not IT specialists, so I try and demystify everything that's going on with that. But for today, we're talking about not in depth what AI is, but how we can use it in law firms without going amiss and awry, how to use it appropriately. If you go to the first slide, I'm going to show you, if you're not familiar with Clio case management system, they're fabulous, and they have a legal trends report that they do every year. And this is from their 2025 one. They found that this is about having AI policies. And when they surveyed the legal professionals in the law firms that were in this study, over half of them, as you see, either said they had no AI policy at their firm, or they didn't know if there was a policy at the firm. And these are in gray because Clio checked and found out that there was no policy at those firms. There's another link that shows that those firms that did have policies, there was a good chunk of the legal professionals working there that didn't know that they had one either, so they weren't aware of it. Very small percentage that actually knew that they had a policy and enacted it. So if we go to the next slide, more than likely, I'm going to say that most of you do not have an AI use policy. Understandable, because it's still very new, and how do you have an AI use policy if you don't even know how you're going to use AI? The problem is that some people think the default should be, oh, we'll just put out something that says don't use AI. Well, that doesn't work, because everything has AI. If you have any browser, it defaults to, you get its little AI function that helps you out. AI is embedded in so many things, and people just naturally want to use it. Not everyone, but a lot of people, especially if they think it'll help them with their time management. So it's really important as law firms that you make sure that you have not only an AI policy, use policy in place, but that everybody knows what it is and is using it. So let's go to the next slide. and we look at what types of things should be in this. So you should have, I apologize, I talked too quickly and probably swallowed a bug. This is approved lists of AI tools. So having sort of a white hat section, these are ones you can use, and maybe even a black hat, like don't use these, like ChatGPT, kind of a difficult one to say is safe for law firms to use. Lots of things that could go wrong with it, and I think Peter will be talking about that coming up. If somebody in the office says, but there's this great AI tool we want to use, then have some sort of procedure for getting AI approved. And of course, at being data protection specialists as well, we would say always involve your DPO or the person who handles your data protection issues. Have a clear distinction. Which tasks is it appropriate to use AI for, and which is it not appropriate for? The last thing that I'm going to do, so the next slide, is the most important thing we should be doing now is to understand that AI is a starting point, never the end. So never create something with AI and then just send it out into the world, whether it be client facing or not. AI is just like having a trainee solicitor doing something. You would never send it out without checking it. That would be a huge issue for you. And AI may seem incredibly smart, and your trainees, I imagine, are very, very smart, but you would never want to send out something they've done because they make mistakes. They don't understand the law as well as you do, or understand the systems, or understand the world the way we do. So always make sure you understand that AI is never an endpoint. It's always a starting point or an aid alongside what you're doing. So to tell us a little bit about, not a little bit, probably more than we wanted to know, but about what the regulations and rules are around AI, or lack thereof, and what kind of trouble you might be getting into, I'm going to pass over to Peter.
Thanks very much, Heather. Hello, everyone. And yeah, so I'm going to go into a little bit of detail in terms of what the approach is when it's coming to broad brush regulation of AI. The approach in the UK is we're following generally a sector-specific approach. So different bits of guidance and regulation are being put forward, and it's important to be cognizant, if we're advising our clients in different sectors, being aware of the fact that some of the requirements are different. So you'll find different things from the Financial Conduct Authority, if you're advising clients in banking and finance, financial services, insurance, as opposed to, for example, law, where we've got guidance from the SRA, or indeed if you were advising an accountant and looking at, for example, what the Financial Reporting Council has said. At the moment, they're not really saying anything that is too much at variance with one another. But of course, what they are saying is more specific and tailored to their specific sectors. But one thing to bear in mind is that across all of this, the position is also that whatever system you're using has to comply with, surprise, surprise, the law of England and Wales. That means it has to comply with the UK Data Protection Act 2018, as amended by the UK Data Use and Access Act 2025. So at the moment, if you take a look at the 𝗫𝗄 website, you will see that an awful lot of their guidance says this is subject to review because of the Data Use and Access Act. Come back in spring 2026, when we'll have hopefully something to tell you, where we'll actually have reviewed our guidance in line with this new piece of legislation. The reason why it is so relevant is the fact that the UK's data protection regulation is now diverging in some ways, in quite a significant way, from the way that data protection law is being regulated and enforced in the European Union. We've got our Data Use and Access Act, where, meanwhile in Europe they're moving towards potentially modifying GDPR through the EU Digital Omnibus, which is only currently a proposal, and still has to make its way through the sort of EU legislative sausage factory until we know exactly what we're going to get out of that. But in the meantime, it means any system has to comply with UK data protection law. That is something that many systems, many AI systems that have been devised and built in California, for example, aren't really built with complying with UK data protection law as absolute top of mind. You may think, So what? We're just going to use it for general research purposes. We're not going to be putting personal data in there. Well, just ask yourself the question, and it's important to bear this in mind, what is AI? We're not just talking about ChatGPT. And I did have someone breathlessly telling me at a dinner I was at a few days ago, they said, oh, we had no idea that AI was coming. And then along came ChatGPT in 2022. And you're like, well, I think we knew it was coming along. Alan Turing was writing papers on artificial intelligence in the 1940s. So certainly people could see it was coming. And indeed, different versions of AI, albeit not necessarily the large language models of which ChatGPT is one, are embedded in a lot of the technology that we use every day. Things like spell checkers, things like the transcribers that we're using very often on day-to-day video calls, as well as some of the other tools that we use. And I very often like to ask the question, and if we're all in the hall today, I'll be asking everyone, so does anyone here use AI? And very often you'll have a few hands that don't go up, and then you say, yeah, but do you use Netflix? And then the hands go up and say, yes, so that means you do use AI because these platforms use AI to work out what your preferences are and what they think you'll enjoy, and then funnel those sorts of programs to you. Same thing with social media. So the point is that we're using AI on a day-to-day basis, and indeed we're using platforms sometimes in law firms that are not appropriate. And that's where it's important to think about some AI guidelines. But if we just move on to the next slide. The key thing with AI guidelines is the idea of then when you are procuring a piece of technology, be it a transcriber, be it something to help proofread documents that have been drafted for clients, where you want to make sure that all the grammar, spelling, punctuation is all absolutely top drawer, depending what sort of systems you're feeding your advice and your documents into. They may not necessarily be the most appropriate system for the delivery of legal services, because sometimes these systems are not secure. They are sometimes not confidential. They can be somewhat leaky. Bear in mind that when you are asking a question or giving a prompt or command to ChatGPT, the freebie version, it takes that information in and could quite easily regurgitate it to someone else because it's learning. That's what it does. I am aware of several individuals who now use ChatGPT for trawling information about what, for example, their opposition might be doing in a tender exercise, or if they're bidding for something. Because very often they'll find their opposite number has used ChatGPT to draft a document, and they can just ask, what is my competitor bidding at? What's my competitor putting together in terms of their bid for XYZ? And ChatGPT will tell them if they just said, ChatGPT, draft that document. Very often, that's what people are doing now. So that's where having a good set of AI guidelines that sort of put in place the questions that you might ask a set of tech suppliers in terms of, is your platform appropriate for the delivery of legal services? That's where you can start to make sure you don't fall into those. I was going to say sort of, elephant trap, and it is an elephant trap, basically. You don't want to end up procuring a platform where you find yourself locked into some long-term deal, when you then find that the platform isn't properly secure and properly confidential for the delivery of legal services. Can we go to the next slide, please? So that's broadly our position in the UK. The position in the US is, as tends to be the case in the US, really exciting and changing on an almost daily or hourly basis. So I thought I'd just give you a little bit of information about what the position is this week. California put in a fairly comprehensive AI law in September, basically trying to say, right, we will be setting forth the way that, if anything, we think this will be a good model for all US states to follow us in terms of trying to regulate the way AI is used. So the idea is that they've put in place a law that will compel developers of large, powerful AI models, known as these frontier models, to provide transparency reports and indeed possibly face fines of up to $1 million. And this was seen as a really big deal by Governor Gavin Newsom in California, saying this is us clamping down on the way that these systems are being developed and trying to put some guardrails in place. However, careful how high you reach, because sure enough, the US president issued an executive order last week, which attempts to stop any states from introducing any AI regulation, basically saying the only regulation we'll have will be federal or none at all. And this was seen as pushing back heavily on that law that California has put in place. And of course, you can imagine that those who are concerned about child safety, not to mention the states themselves, are not particularly happy with this. So this is seen as a sort of a victory at the moment for the big tech companies. They're getting the exact position they wanted, which is a very low regulatory environment across the entirety of the US. But as you can imagine as well, the legality of that very executive order itself is now being questioned. But of course, at the moment, that executive order is out there. It could take months or years until it faces challenge. In the meantime, we're going to be getting a very confused picture from the US in terms of AI regulation. The point being, companies can carry on developing more exciting AI products, and they'll just be distributed around the world, and we'll end up seeing the impact of that. So my next slide could just be a large, big question mark, but instead it isn't. I wanted to look at what's happening in the UK. I wanted to just draw attention to the fact that we're familiar with lawyers using AI. I could have put up case after case here of examples where AI has hallucinated, lawyers have relied on it, but litigants in person are starting to rely on it as well. I'm sure many of you will have, when you've sat down with clients, you'll sometimes find it quite interesting when your client says, oh yes, I've drafted something using ChatGPT, and you try and stop yourself from sort of raising your eyes to the ceiling. But you then said, oh, that's really interesting, let's take a look, and then you'll review it. But in this instance, we've got litigants in person who are drafting things, relying on AI to help them. And indeed, this has now been looked at by a specific case in a case involving a child, this child D, this case was, where the judge said, I absolve the mother of any intention to mislead the court. Litigants in person are in a difficult position, putting forward any legal arguments. Used properly and responsibly, AI can be of assistance, but it is not authoritative or infallible. Key words there. And of course, the judge talked about the problem of hallucinations, and sometimes the fact that cases are cited where those cases simply do not exist. And of course, it's then hoping that the court or other parties pick up on the fact that there is reference here to cases that are total hallucinations. Can we move on to the next slide, please? Because, of course, last week we also had an example of a 300-page judgment that was delivered where, while there were, of course, 300 very detailed pages, everyone zeroed in on the fact that there are a few references to cases that may indeed be non-existent, or certainly examples of references to cases where the reference saying this judgment says X, Y, Z, it's then been found that it doesn't say that at all. We've got a quote there from a professor of law at Oxford University, Dr. Michael Foran, who said, it's an incontrovertible fact that judgments include supposed quotes from specific judgments that do not appear in those judgments. As is usually the case, then, the really juicy bit is the quote from someone who didn't want to go on the record, but they've made it very clear. They're saying the most charitable explanation is the judge used AI and it hallucinated. But whatever has gone wrong, this is extremely serious and completely unprecedented. I found it very interesting looking at some of the comment over the weekend where there really were a number of people saying this goes to the heart of issues on the rule of law here. If people lose faith in the judgments that are being delivered being the clear fountains of authority that we expect, the consequences of that will make it very difficult for the continued administration of justice, particularly then if we get into a world where there are fewer juries delivering verdicts as well when it comes to the criminal law. But that's not for us to discuss today. Can we go to the next slide, please? So the CCBE have issued some quite interesting and helpful guidance, which I can certainly recommend. It highlights the main issues we need to think of when we as lawyers are using AI, going to the heart of issues around confidentiality, competence, independence. Transparency and information to the client is key, particularly if sometimes we as lawyers might be using what in effect are black box systems where we can't really be sure how the AI is producing its advice, its guidance. So if we can't be sure how and why it is doing that and what information it is basing its views on, how can that be articulated to the client? Then it goes into, of course, the consequences, the issues with regards to the fact that you may indeed face significant professional sanction if you are found to have used AI in a way that it's manufactured cases, or you simply haven't checked what the AI has drafted. As Heather was quite rightly saying, very often you need to treat anything that's coming off these systems in the way that you would from a very, very junior lawyer, paralegal, etc., where you basically have to double, triple check it to make sure that what it is saying is right. And at the moment, very often what I'm seeing, both from lawyers and non-lawyers, is that the information that comes out from the AI is almost being treated as incontrovertible. I know of one individual who works in supplying law tech systems, works in-house to a significant law firm. He attended a conference where both Heather and I spoke, and we talked about hallucination. And at the end, over a drink, he just very calmly said, well, I don't think there's any problems with hallucinations with the systems in place in our firm. It's all absolutely fine. And you go, really? To which I've then spent the last 6 months, when I find examples of hallucinations, sending them to him. For a few months, he would turn around and try and say, oh, well, that's a different sort of example, but he's given up fighting with me on it now. I think I may have won that argument, hopefully. But the point here is that there are very real sanctions that you'll face if you're relying on this stuff to your detriment or to a client's detriment. And the damage to a reputation could be not just long lasting, but let's face it, permanent in terms of what could happen. I've also talked already about that inadvertent sharing of information, the fact that things can be put into prompts, things can be put into these systems that may indeed mean that confidentiality is at risk. And indeed, things like there can be a significant conflict of interest that may be revealed as well. And you need to think of all of these issues when we're embarking on the use of AI. If we can move on to the next slide, please. The Bar Council have just issued some really helpful and helpfully up-to-date guidance as well that actually refers to cases this year where there have been significant examples of AI running awry. So the first one there, basically that refers to the London Borough of Haringey. In that case, lawyers denied using AI, but counsel submitted pleadings before the court that contained 5 fabricated legal citations, including a non-existent Court of Appeal case, and misrepresented a statutory provision, the 1983 Housing Act, as mandatory. They said must rather than may. Now, of course, non-lawyers tend to think, well, so what? We as lawyers then say, well, actually, the difference between a must and a may is the thing that we spend hours fixating about. So it's actually really, really important. And then the second case there was an issue, basically Dame Victoria Sharp in that second judgment issues a warning. There are serious implications for the administration of justice and public confidence in the justice system if AI is misused. In those circumstances, practical and effective measures must be taken by those within the profession and within individual leadership responsibilities, such as managing partners and head of chambers, and by those with the responsibility for regulating provision of legal services to ensure that these problems do not affect the delivery of legal services. Those measures must ensure that every individual currently providing legal services within the jurisdiction understands and complies with their professional and ethical obligations and their duties to the court if using AI. In hearings such as this, the profession can expect the court to inquire whether these leadership responsibilities have been fulfilled. So I think that judgment there in particular goes to the heart of certainly what the judiciary is saying that they should be expecting from lawyers who are engaged in representing their clients before the court. If we can move on from there, please. Next slide. So I'll now hand back to Heather. Hopefully I haven't gone too much into down the rabbit hole of apocalypse there, but I'll pass back to Heather to pull us back.
Okay, thank you. And just to know, and I'll double check this with Peter, but when I was talking about AI use policies, that's something digital law does for its clients, isn't it?
It is. So we've been doing a lot of work around designing those bespoke AI guidelines that you can embed into an organization. The point being that then once they're in place and they're an organic document that will grow and evolve over time, this is something that will govern the way that your approaching the use of AI, the way that your staff are trained on the use of AI, the way that staff are trained not to rely on the freebie AI products that could put the firm at risk, but will only use authorized products that you have purchased through your guidelines, so you know that they are safe and appropriate to use. And indeed, it will ensure that those risks are closed down. So then if you did find yourself in this sort of scenario where you've got there the judiciary expecting that certain standards will be met with regards to the use of this technology, you can turn around and point to your AI guidelines and say, look, we're demonstrating compliance with what you are expecting us to do. It also means you can comply with the guidance that's been issued by the ICO, and then some of that sector-specific guidance that we were talking about earlier. If you've got a good set of guidelines embedded, it's the thing that you can use to ensure that you are getting the most out of the use of the technology, doing it in a safe way, in a compliant way, and in a way that hopefully will mean that if you do find yourself on the end of a problem with regards to a hallucination or something that could mean that there is a problem with the way that services have been delivered, well, you've done all that you could be expected to do, given the size of your organization, given your resources. You've done all that you could be expected to do to try and ensure that the worst didn't happen.
Sorry, I didn't mean to get him started again. I apologize for that. It was yes, no question. All right, so one of the people I know who can answer a yes, no question with a 5-minute lecture, but he knows his stuff. What do you need it for? So this is when I'm saying, let's figure out what do you need it for. Let's figure out why you're looking at AI and what for. And I think that we don't tend to think about it in law firms. We're just like, oh, we saw this advertisement. Wouldn't that be, we saw this sold to us. We get email after email and sales pitch on LinkedIn and all of these things of this is the AI that's for you. Instead of doing the internal audit first, what could we be using this for? There are 3 main categories of which this can be used, which is back office or administrative tasks, the non-client facing client services, and the client facing services. If we can go to the next slide, I'm gonna go back to the Legal Trends report because it looked at one of the things that they found was this administrative or back office, which is mostly back office and a little bit of non-client facing work, that's where we are the most inefficient as law firms. And they said the most effective uptake of AI by far was those administrative tasks, reducing those redundancies, those friction points, those inefficiencies in how you're running your practice in general. So using the technology to really streamline how your firm works is the most successful way of implementing in law firms. Instead of this sort of what's getting sold to us is more the client-facing stuff, which is not as helpful, at least at this stage, particularly with the confidentiality and data protection issues. If we look at the next slide, please. In fact, once these have been implemented, they actually surveyed these firms that were using AI, and a vast majority of them were saying, 77%, it's just operations were improved if you use AI properly. Operations, that means, the document reviews, the document producing, doing all of those niggly things that you do that a lot of times you cannot bill for. They don't create billable hours. They don't create any sort of resource for your firm. So cutting back on the non-billable time in your firm. And also 26% said if they used it, it boosted their sales and marketing. Now that's something that I know in particular, my experience in law firms is just, we can be really bad at sales and marketing. It's not our skill. And if AI can really help us with that, that would be great. Whereas benefiting the client experience is only about 10%. And only 5% accuracy. And that 5% accuracy is probably for those who have the really well-honed, well-placed AI, because it's really becoming well known, particularly in the US where this survey was primarily done, that AI is not something that really helps with accuracy, at least at this point. So if we can focus our energies in looking at AI on things that we actually need internally at our firms, then we can be better equipped to sort of fend off the sales pitch stuff and avoid those things we don't really need, which may actually end up causing us more problems down the line, and actually use them to make us more productive and more efficient and less likely to be sued because we had our AI hallucinate something. Next slide. So we've got that improving. So we go back to this back office, non-client facing. However, there are some cases in which client facing works. So I'm going to show you two case studies, small ones, and I may talk about a few others since we have a little bit of time. Obviously, Digital Law, I work with them. There's grammar checking, social media posts, and biographies. That's largely what Digital Law uses. People think, oh, it's Digital Law. They must be using all of the AI. Well, at this point, there isn't really a lot of AI out there that will assist Digital Law in what they do because it's so specialized. You can't go on to a generative AI and really do any portion of the majority of our jobs. Even grammar checking, as we said before, should never be an endpoint. We do run things through a grammar checker at Digital Law, but it's always, we do it with anonymized documentation. So we never put in client names or any documents through it that could really identify who the client is or what's going on. So it's a very precise thing, and it's always done just as a check. It's not the final grammar check. So I don't know if any of you eagle eye spotted it, but there were two spelling and or grammar issues that happened in a couple of the slides. That was unintentional, but a grammar checker wouldn't have caught either of the two major ones. One of them was that Trump's executive order was restricting states. It said sales instead of states. AI didn't know the difference, so it wouldn't have caught that. Later, it was a reference to when the case was out, and it read 1383 as opposed to 1983. But again, that's not something the AI would catch. So this is an example of how you should not rely on even something that seems as straightforward as grammar checking, right? So you can say grammar checking is great for that. One, you have to make sure your confidentiality and anonymity is being protected, that your copyright, the stuff you're writing, is being protected. So if you're using one of those. Social media posts, again, this goes to the fact that marketing and sales for law firms can be helped with this, because obviously for a small niche firm, they don't have like a whole sales and marketing team, and using generative AI to help draft posts, not final posts, but to help draft posts to make that process quicker is great. Biographies, this is something I use not just with Digital Law, but with my company, Anson and Peter Wright, because for one, I hate bios. I hate writing my own bios. It's awkward. You're talking about yourself, and ew. So I like using them to give me at least first draft of bios about myself. We all and in my business also to help me out with short articles, like the first draft of something, but always just the first draft or the stepping off point, the outline of something, never the final product. So that's an example of, even though Digital Law is a high-tech firm that knows technology and does technology, it's being very cautious, and the AI use policy is quite sturdy in that and all the employees know it and use it on a regular basis and know what they're supposed to be using, what they're not supposed to be using, and how they're supposed to be using it. And the uptake is slow but thoughtful. I'm using the next case study because this was one that I worked on, which impressed me with the way the firm actually did the analysis of what their firm needed and then got specific AI for this. And a lot of people don't even know this is an option. So this was a niche law firm that did a very, very niche form of law. And since there were only a small number of experts within that firm that did this, they felt they really needed to use AI to create a knowledge bank that would make it not only easier for those few experts to do their job more quickly and easily, but to go on vacation. Sorry, that's the American in me. Go on holiday, because if they're only ones who know this, and it's really hard to just tell somebody, oh, go sit here and research all of our files. They essentially bought what's called an off-the-shelf LLM, which is a large language model AI, which you can do, which it's sort of a pre-trained AI in some sense. It's got all the languages, it's got some of the guardrails, and then you can hire programmers who can specifically then hone that AI into a very specific task. So this isn't one that's going to be connected to a search engine or to some big company. This is literally sits on their server, and it takes in all of the knowledge, all of the information that this firm collectively has and continually is added to, and allows them to not only be able to find case law and information quicker, but to train new staff to make their firm not just those few experts, but those few experts and a growing number of other experts, and their firm can get larger without having to take the time to really have to train those people. That is a really wonderfully concise and forethinking way of using AI. And you'd probably be surprised that this cost this niche firm, I believe, less than £40,000, including the purchase of the LLM, to create. So that's an amazing, powerful tool that they didn't get sold as they thought, what do we need? This is what we're going to create. Now, these are the case studies, but some of the other things that firms are doing, if you're going to be using AI for legal specific jobs, the generative AI out there is not appropriate. The ChatGPTs, no matter how well they are, their what I call their boundaries or their rail fencing is not made for law, which has a very specific set. This is why the hallucinations happen, because they don't know that case law is a specific thing. They just see it. These generative AI models see it as a formula. Case law looks like this. Case law comes out like this. That's why they hallucinate it, because they don't know. I say they like it's a thing. AI doesn't know that what you're looking for is specific case law. It thinks you're looking for stuff that looks like this and says that. So it will find, in quotes, but what it will do is, if it can't find something, or instead of finding it, it just creates it, because that's what it's there for. It's generative, it creates it. So if you're going to use stuff for client-related matters, you need to look at AI that is specifically targeted to the legal market for several reasons. One, it's going to have those guardrails on it that says only pull case law and case references and legal references from this very specific set of information, like the law firm that has the knowledge base. You may have all of the vocabulary in the world, but we're not telling you to create this stuff. We're saying, pull it from here. Find it for us within this very specific database. So for research, only use AI that has a specific library of language, which is actual existing laws, guidelines, regulations, and case law. And even with that guardrail, make sure you're double checking it and triple checking it. The other thing is that if it is targeted at the legal market, they are more likely, not definitely, more likely to have put some thought into the regulations required within that. However, they may not always do this. So I'm going to bring Peter back in, because the two of us together are going to talk to you about how to sort of analyze these systems that come to you. So some of them may come to you. You may be going to the market and asking for these things. So what questions should you be asking them once you find them, hoping that, instead of just hoping that they'll be doing it and relying on them to do the job? So we have first, where are your servers located? And Peter, can you tell us why it's important to know where the servers are located?
So really, this is going back to that point that any system has to comply with the basics of data protection law. And this is where some systems can fall to the ground very quickly, because depending where your servers are, you need to make sure that wherever they're located, there is a means of being able to store and retrieve potentially personal data from them, depending on what you're going to be using the system for. So, for example, giving that example of an AI transcriber I was giving earlier on, if you've got a transcriber that's recording calls between you and your clients, or between staff potentially discussing fee earning work, you're going to want to make sure that you know where the servers storing those recorded calls are going to be. If they're in the UK, no problem. If they're in Europe, we have an adequacy arrangement with the European Union. That means it's okay for personal data to be stored in the EU and for data to go back and forth from there. Beyond that, things then start to get a little more complex. You can absolutely have your servers located in, the Middle East or Canada or wherever they may be, if you've got the right arrangements in place. If, for example, you've got a contract with a third-party cloud storage supplier, if that contract contains the appropriate standard contractual clauses, as mandated by the UK Information Commissioner's Office, and furthermore, the contract is valid. If it's a fixed-term contract and they've expired, it's no longer going to be in place. And provided that they are the right standard contractual clauses, not the old ones. If they're the right ones, you're okay. Or it could be that you're using a large organization that has binding corporate rules in place for the storage of that data and also that personal data to be securely moved around within that organization.
Let's say the easy answer to this is you ask the question, where are the servers located? If the answer isn't UK, European Economic Area, or one of the few countries that have an adequacy decision, then either avoid that one or ask the provider what is in place to ensure that data transfer is legal in this country. So that's
exactly.
We can talk about what the law is, but that's the quick questions for them to ask. The takeaway is ask them that and come away with it. And the same thing for the backups and the primary servers, correct?
Yeah. It is. I mean, the final point I was going to make there was just with regards to that supplier that was found to be unsuitable in terms of a transcriber. Their servers were located in America, and they were not what you can search on the EU US privacy framework register. You could search for the individual companies, and that company wasn't on there. So when you suddenly have got cross against all of those different mechanisms, it's not appropriate. But as Heather says, it's just that asking where the servers are and being able to very quickly work out, okay, the further we go away here from the EU without those safeguards, the bigger problem we have. And those same issues then apply to backups. Furthermore, make sure that any backup that is on there is actually a true backup, saying that your backup is actually located on the same server as the primary servers, which happens a lot when we ask these questions, isn't good enough. Because guess what? When the primary goes down, it takes your backup with it. And as we've seen happening a lot in the news this year, no system is too big to fail. The Microsofts, the Amazons, etc., Shopify, whoever it may be, they can all go down. And when they go down for a period of time. Will your business be able to survive if that system is down for 12, 24, 36, 72 hours?
Yeah, and so making sure that if you have AI systems, that if you are storing data on there that's important, that there are ways to access it without that system having a redundancy in place, or what I like to call not putting all your eggs in one basket. Then the next important thing I would say is looking at the break clauses or the minimum contract terms, because a lot of firms get into trouble with contracts where they think they want this and they get into it, and then it turns out it is nothing like it's supposed to, or the rules have changed, or they move the servers, it becomes non-compliant, and they have an inability to get out of the contract. So law firms in particular, at this stage of AI, bringing on AI, unless you've bought it yourself, if you were just using it as a software as a service or a SaaS service, which a lot of them are, that you need to make sure that you can get out of that. It is too new for us to be committing ourselves to long-term contracts or for contracts that don't have a break clause in them. It is something that companies use to try, and once you figure out this isn't great, we get to keep you anyway. We know at least one case management system that does that and makes it very difficult for you to get out of. So really, really important to make sure that you can get out of it. Technology is too new. Make sure it's easy to get out of. And don't just let them tell you that. We are legal professionals. We can read a little and just look for that clause. How do I get out of it? And know that you can be that can be enforced. Then we have the security and encryption. This goes back again to not just data protection, but your requirements as a law firm to ensure the confidentiality of your clients, to secure your practice in general. Because AI systems are what is called a supply chain software. It is part of especially if it ties into your system, it can be a way for malicious stuff to get into your system. So making sure that if this is a plug-in AI, if this is going to be plugging into your system, is it responsible for security? Does it have encryption strong enough that you feel it is safe enough to have it attached to your system? Because so many of these are, again, oh, it's so easy. We integrate with your existing system. Cool. But by doing that, have we just left the back door open or the key under the mat where everybody can find it? So you making sure that whatever is plugging into your system, if it touches your network at all, that it has a level of security and encryption to it, so that it doesn't mean it won't cause a problem, but that it's less likely to cause a problem, and that they take responsibility for it. One of the things I find so disheartening about a lot of these tech contracts is that their liability clauses, really important to look at the liability clauses, basically say, if stuff goes wrong, it's not on us, it's not our fault. So if they cause your firm to essentially collapse, they basically say, yeah, sorry about that, but you did sign a contract saying that we weren't liable for it. And again, as law firms, courts are not going to have a whole lot of sympathy for you, because that's one clause. So just make sure that they are basically willing to accept responsibility for something that may go wrong because of their system. If they're not, it is genuinely not worth the risk. I don't care how shiny and wonderful this product looks. There are firms that were taken, many firms that were taken down and out by technology contracts that basically went horribly wrong. And they said, sorry, you signed a contract saying we wouldn't be liable. All right. Have you taken any steps to comply with online safety? I think I'll go back to Peter on this. And again, just asking the question, but why would they be asking this question?
So the reason why this is in there is that the Online Safety Act is now being regulated and enforced. And for some of the larger and freer large language models, where they are free at the point of access and anyone can ask a question. In that instance, then you could have those who will be classed as children under UK legislation could be using it, and what happens to their personal data. So the answer for a lot of, hopefully, the sorts of platforms that law firms would use would be the way they comply with the Act is by limiting how people can access the platform, saying that you can only access this if you have a login and that's been provided to you as a customer, and we know that you as a customer are an adult. That means you're demonstrating compliance with the Online Safety Act in a very basic way. We've worked with a number of clients to make sure that they are demonstrating compliance with this piece of legislation, because they wish to be able to say to Ofcom, the regulator, you don't need to worry, we can demonstrate that our system is fully compliant with this, and we have sufficient measures in place to demonstrate that children cannot get onto it.
So
that's something you should find from any supplier, that they'd be happy and easy to demonstrate to you what measures they've had in place.
And most firms may at some point be processing the data of children, or children having access. So it's important for them to be able to say, yes, we are compliant with the Online Safety Act, and put that in writing. Now, most firms, if not all of them, should have a data protection officer or an outsourced DPO. We do a lot of outsourced DPO work, both at Digital Law and Anson and Evaluate. Digital Law handles a lot of law firms and other regulated entities. But one of the things we recommend highly, and that we do, are data protection impact assessments around AI and other software. So a data protection impact assessment essentially will look at what is the tool that we're looking at bringing in, what kind of data are you processing on it, and what are the risks to your data processing, and how are those being protected, and is the worth of this product balanced by the risk? So it's a risk analysis system, and DPIAs are generally required for most major system changes like this for AI. So we can open up to questions. We can also let you know that we are, both myself and Peter, are what we do around technology, law, data protection. We do training in firms. We do data protection outsourced. We also, Anson and Evaluate can go into firms and help you evaluate what your needs might be for AI or any tech, and help you implement that safely. And Digital Law, make sure you have all your policies and procedures correct and in place. So questions?
Yeah, so absolutely fascinating stuff. There's so much going off in my mind as you're going through here and different angles of it. And one thing that I just kept thinking about was having all this governance and control and getting it just right in the law firm. That's actually the easy bit. It's controlling how your staff and people use that. And particularly because it's so accessible, everyone's got their computers in their pocket now, and AI is so accessible. There's that real risk that it's being used and you know nothing about it, even if you've got a policy. And there are some examples we know where firms are trying to sort of lock down systems and make sure, you only have to do, can only go through this route. But I think that doesn't fix it, because there's always a workaround. They'll sort of, in fact, make it worse by taking the data off that system so that they can access it. So do you have any advice about that particular issue?
Yeah, I do. And actually, we found there was a great example in an assessment that we did at a law firm once, where they had this great system for ID checks. And the person on reception who was having to handle these, the system was it didn't function well enough. And so it was just easier, she said, to take photos on her phone of the IDs and then email it from her personal account to the law firm account, and then upload it on the system. And they had no idea, the firm had no idea she was doing this. And the answer to this is, one, making sure your staff is trained, not just say, don't do this, and don't do that, but here's why. here's why it's important. So I always say, instead of scaring them, and they don't get scared. They don't get that. They think, but it's so good. Well, think of it as that this stuff is like gold dust, and if you don't use it right, we lose all of that, and it's costly to the firm if you don't do it right. So it's so important. But the other thing is making sure that the people who have to interact with the your systems and your services every day, the staff are involved in the process. That's another reason why those break clauses are so important, because you may think this is a great bit of kit, and us at the board level, we've all decided this is great and we've implemented it, and the staff is just like, well, that doesn't work, so we just won't use it, or we'll go around it, or it's just easier to go on this. Involve them with that process and have them tell you what's working and what's not working, because in the end, if it's not working for them, it is not going to decrease your friction. It's not going, I mean, one of the big things with these transcription things is they would bring it on and the staff had no idea how to turn it off if they were having a call that it was inappropriate to have it on. So just all those little things are important.
As well as the safeguards and the warnings, I think it's really important to look at. There is a hunger for staff because they want to do things easier, and what's the forefront. So I think there's a responsibility on the firm there to think, actually, what is cutting edge? What do our people want to improve the service? Because they will use it, because there'll be that hunger, because they'll know that the technology is out there. So not just always closing down to what's safe and shutting it down, but also what can we open up in a safe way.
And that's why at the beginning, when I was saying your AI policies, part of that is having a procedure saying, don't worry, we're not saying never use this. I say, if you find something that you like and you want to use it in the firm, here's the process we'll have to go through to get it approved. And if we don't approve it, we're going to tell you why. It's because it actually violates law. It doesn't comply with law. Unfortunately, they're requiring a ton of money up front, and we're locked in for 10 years kind of thing. So again, having them empowered by being able not only to give you feedback, but giving them a process to try and get things approved that they think is good.
We've got a curveball question in here, and it may be a subject for another webinar, but we'll see where we go with it. But position on professional indemnity cover for use of AI. I mean, there's so many different ways you could go with that, with negligence claims, or does anyone want to handle that curveball? Thanks, Nina Dayal, for that question.
Well, I think a key issue here is going to be exactly what your PII policy wording says.
Yes.
Which is always the case with so many, where, guess what, very often the insurer may try and wriggle off the hook. If they can say, well, we did have this exclusion here, and if we try and drive a horse and cart through that, the fact that you hadn't necessarily got any guidelines in place, you hadn't trained people, that you hadn't looked at identifying any risks, carrying out, as I was saying, an AI DPIA to identify risks and manage and mitigate them, may mean that as a result, the fact you just stampeded into using the AI and a claim was developed as a result, we're not going to cover you. The thing to bear in mind, though, is, as with always the case, you can put two PII policies on a table next to each other, and you'll suddenly find that what they cover and exclude is wildly different. The same way you can have two cars, and one's a sports car and one is an SUV. Both cars both do very, very different things. Same thing with PII policies. So that's probably as far as I can go on that before we contact you.
I think it's sort of shiny AI stuff, but sometimes, and I completely agree with what you've said there, Peter, about what the actual wording is, but it could just be good old-fashioned negligence there with how they're using AI, and with the minimum terms, they're always going to have to pay out for those first-party.
I'm sorry to interrupt. It's not also just the PII. It's also the required cyber insurance that you have. And that, again, it's funny. We have some trouble now getting law firms to actually do their appropriate cyber training. And one firm that we work with that's great on it has started reminding firms to look at their policies and see if they require certified training. And most of them do. And if you don't have that certified training And not just, oh, we have something internal or we signed up for something. It has to be the specific training. They're doing that because they want to be able to deny that coverage. And so check your policies. If you're required to have that training, you need to have that training.
We do have one question here, and it potentially is a long answer, so we may have to just cut that short and see, because we are on the hour. But there's a question here. There's a lot of talk about storage outside the UK, and that question should be asked: what would be green flags? What answers are you wanting to receive? What would be green flags? Specific good examples on what to expect. Might be easier with the red flags, but
well,
a nice little
UK EEA is green flag.
And if they can actually answer the questions. So if you're asking a fairly straightforward question and you're expecting that sort of straightforward answer, if they're not giving you that straightforward answer, then that is a red flag. So I suppose it's easier to swap the red flags other than if it's, green flags. So.
Basically, if you've got a supplier that's outside of the EEA, and they should have those standard contractual clauses present on their terms.
And data
that's
transfer.
what you're looking for.
Yeah.
Or if they're in the US, they've signed up to the EU-US privacy framework.
Mm-hmm.
So fantastic. We are on the hour now. Where can people find you if you've sort of spurred them on to, okay, yeah, we need to get this sorted, but we need help? Heather and Peter, where can they find you, and what can you do?
Peter, let's see. I'm my social media and my presence is horrible. So, but I am on LinkedIn, and you could always email me at heather@digitallawuk.com or ansonevaluate.com. I'm available on both, and I make the beginning bit easy. It's just Heather at. Peter, yours is more integrated.
So yeah, I'm on peter.wright@digitallawuk.com. You can also find me on LinkedIn, and we've also both Anson Evaluate and Digital Law are both present on LinkedIn. Have the company pages on there. You'll recognize them from, you'll see the company brands that you've seen on the slides on there. We also have a digital law podcast that is produced by Anson Evaluate. So just search Digital Law on Apple Podcasts, on Spotify, and you'll find us. You can follow on there. We also have a digital law YouTube channel, which basically contains the raw videos that we take when we are recording podcasts, recording webinars, and it's all stored on there. And then we take the audio off there and put that out as a podcast. So if you want to sit and have the video in the background, you can do. If you want to have something to listen to while you're walking the dog, you can do, either way. But that's where we are. We are also on Facebook and X, but to be honest, if you've got a LinkedIn account, I'd recommend just following on there.
Fantastic. Well, I can't believe how fast that's flown. It's been absolutely brilliant. If there's any questions that you wanted to ask Heather or Peter, and other than reaching out to them directly, just message into Hive as well, and we'll make sure we get those answered. But yeah, so the next What's the Buzz is on the FCA AML consultation, which is on Friday. So there's a deadline of it's actually Christmas Eve to get in a consultation if you want to respond to that. Our head of risk, 𝘱𝘰𝘁 is doing a online workshop. So it's not webinar format, it's more workshop Zoom meeting format. So do look out for that and sign up if you are thinking of answering that consultation. But for now, thank you everyone, and you will be sent a copy of the recording by email. Lovely. Thanks everyone.
Thank you.
Bye-bye.
Bye.